welcome to our YouTube live stream this morning. My name is Matt Fort, and I'm going to be hosting it. I'm a digital reporter here at NBC 10 Boston. Now, we wanted to hop on YouTube today to give you an update on the Brian Walshe trial, and here's why. So today we were expecting Brian Walshe to be in court, and we were hoping to be able to bring you an update from a court hearing this morning. It was supposed to be a competency hearing because he has been staying at Bridgewater State Hospital for a mental health evaluation to determine whether or not he is competent to stand trial at this point. So we were thinking that was scheduled this morning, and it was scheduled, but that has been pushed back today. And he's not expected to be in court until the middle of November. So his stay at Bridgewater State Hospital, it was originally supposed to be just for 20 days, but that's been extended for a couple more weeks at the request of staff at Bridgewater State Hospital. And last week, the presiding judge over his murder trial, Judge Diane Frenier, she okayed an extension to his stay there for this mental health competency check. Now, this all happened after he was allegedly stabbed in Norfolk County Jail in September, and Brian's lawyers say that sparked kind of an unraveling of his, and he's been having trouble contributing to his legal defense discussions and remembering things and things of that sort. So doctors are currently evaluating him. We were thinking, again, it was scheduled that he would be back in court today, this morning, and there would be some sort of report available on his mental health and ability to participate in his own trial. But again, that has been pushed back a few more weeks at the request of staff at that hospital. So that's where the trial stands. It's been pushed back again, pending all of this. And we're going to try to help you understand everything that's going on, because there are a lot of legal processes at play and things that have to happen also before Brian goes to trial. He is accused of killing and dismembering his wife, Ana, at their Cohasset home in early 2023, so almost 3 years ago now. And there have been a lot of legal battles unfolding over the past year, especially with some overlap involving former state trooper Michael Proctor, related to some fallout from the Karen Reed trial. So there really is a lot going on here before this case really goes to trial. So our law enforcement reporter, Robert Goulston, he was covering some of these scheduling changes in the Walshe trial last week. And during his reporting, he spoke to criminal defense expert Peter Elkin about what exactly it means to be found competent or not competent in the eyes of the court, how long this typically takes, and what is involved in that process. So I do want to play you an extended cut of that interview, because there's a lot of really interesting context to know if you're following a case like this closely. So take a look at this interview of Peter Elkin by Robert Goulston.
The Brian Walshe murder trial was scheduled, and then last minute there was an attack in jail reportedly, and then there was a request to do a competency hearing. What does that mean?
Well, it is crucial that a defendant be able to understand the proceedings going on around him and be able to assist his lawyers. And if you can't do that, then you have to postpone it at least a while till you're back in good shape again.
Can you talk a little bit about the competency being requested so late in the process, right before trial date was scheduled?
Well, they had no warning that they needed a competency evaluation until he was attacked in jail. Otherwise, if they had just had general misgivings for the last year, they could have expressed it much earlier. But I think there's a good reason why it came at the last minute, that when he was attacked in jail, and then it turned out that he needed to be evaluated, that he was not as competent as expected.
That's true. And then the nature of the attack, he was reportedly stabbed or maybe slashed, and then it was beaten. Why is it? Why could that have an impact on somebody who's in custody awaiting trial for the murder of their wife? What could that do to someone to cause some sort of incompetency?
Well, in this case, it seems like the physical injuries were not that severe. However, it's hard to judge on the mental effect it would have on you if you were attacked and stabbed with a knife. For a lot of people, that could have a dramatic mental health effect on them, at least temporarily, maybe not for the rest of their life. So when we're questioning his competency at this time, it's unlikely that that would permanently stop the trial from going forward, but the defense may be requesting a little more time if he's not ready to assist in the defense and not able to assist in the defense at this time. And that's really the key. Otherwise, if they went ahead with the trial where the defendant was not able to assist in the defense, that would be appealed and it would be thrown out, and at some point they'd have to have a redo. If it can genuinely be shown that he would not have an understanding of the legal proceedings around him and be unable to really competently assist his lawyers in his defense, then it really should be postponed until such time. However, courts are often skeptical of claims where people say that they are not mentally ready for a trial, because anyone facing life imprisonment would probably be nervous and very stressed and upset and distraught. So that's why they are simply not going to postpone trials, because somebody's stressed and distraught at the fact that they are facing imprisonment for the rest of their life. And that's why a judge is going to want to be really clear and have a really good evaluation done to determine whether the person at this time can understand the legal proceedings around them and assist their lawyers in their defense. That is crucial. So it's not unusual that somebody would ask for at least a postponement until the time that they are ready to go ahead with the trial.
And how is competency determined? What is actually happening at Bridgewater right now?
I'm not sure exactly. I don't know that I can answer the exact nuances of the forensic psychologist evaluations, but the bottom line is there an understanding of the legal proceedings around them, and does the forensic evaluator think that they'd be competent to assist in their defense? And they do that through a series of particular tests and just their own evaluations.
And is it key to have it done over a longer period of time? So it's not just a one-time go in, are you mentally competent? It's an evaluation over a period of time?
That's why it's not uncommon that the 20 days evaluation at the hospital is continued, and they're given another longer period of time. It is not simply a one-time interview. And also the therapist and the forensic psychologists have explained to me that they also have a series of ways to determine whether somebody's simply faking it. Because a lot of people would just say, oh, I'm so nervous and stressed and I don't know what's going on. And they might just be faking it. And the forensic psychologists are ready for that, and they say that they have a variety of methods to really determine whether somebody is malingering and faking it, and that's why their evaluations are usually rather well done.
Gotcha. And then the other question was, the state originally, we had a trial date. It was postponed because of the evaluation requested. Yeah. Now the state's coming in and say they want to have a date on the books so that they can start lining up witnesses and stuff outside of state. So they need a hard date on the books. Is that something that's typical too from a planning, so they can just continue if need be? If he's not ready or he's not competent, they can continue, but they had to have this November now 18th date on the books.
Yeah, they always prefer to have a hard and fast date, because they do have to make plans with schedules to bring people in from all over the place. And however, those scheduled dates are often continued again and again.
Gotcha. And with this mental evaluation, typically in your experience, how long does it usually push it out? I mean, they're saying November 18th is the next date. They did extend it for another 20 days for the evaluation, so now he's not going to be supposedly done with the evaluation until November 14th.
It varies. Typically, they really do put the trial off for several months, for at least 3 months or so, and take a look at it at that time. But I know that they're always under the gun and really want to keep to the schedule as closely as they possibly can. No one wants needless delays and for cases to drag on. There really should be a speedy administration of justice. However, as long as it takes, because you don't want to rush somebody in and they're not competent to assist with their defense, because that's going to blow up in the face of the prosecution when the verdict is thrown out in the future by the appeals court, and they have to have a do-over of the trial.
And if he's ruled incompetent and then they can't rule him competent even down the road, kind of what happens? Do you know the?
Normally, if somebody has been basically competent their entire life and there's been no hint of mental illness and something happens to stress them out for the trial, almost inevitably they do the trial in the future. If you could show someone is permanently going to reach the standard of Massachusetts insanity defense, then I guess you would never have a trial, or you would have a trial where you would determine whether they qualify for the insanity defense. But this sort of trauma happening after the person's charged is almost inevitably cleared up at some point in the future.
The other question is, why is it important to have the person technically there, so to speak, competent? Participating day to day on the trial.
Yeah, it is so crucial that the defendant is there, because often things are brought up where the defense counsel has to turn around and say, well, what happened on that date, or what happened in the past? And everybody has a right to kind of also tap their lawyer on the shoulder and say, hey, you know, you forgot to mention this, or you should bring this up. Two heads are better than one. And that's why if your life is at stake, you really need to have some input and saying it, because you don't want to have a trial where you're gagged and say nothing, and after the verdict comes in, you'll say, but you know, you didn't point this out, or you forgot this, or they made a mistake here.
And the other possible delay now is the proctor potential evidence that's coming out of the request to get some access to the Reed evidence, and then these personal cell phones. What does that do to the process too? And can you talk a little bit about getting access to information to try to prove that this investigator may not have been doing his job the right way?
You never want any unnecessary delays in the speedy administration of justice. However, you need all the ducks in a row. You need to get all the information. Everybody's got to be ready for trial. This is not a race to the finish line. Everybody has to be completely prepared to give the fairest trial possible. That's why if the mental competency or proctor's statements are going to take a little bit of time, then you really have to allow for that, because you want the fairest trial that could possibly be given, and you have to be ready, and all the information has to come in. You can't just rush to judgment as a race to the finish line. They would really have to, concerning the proctor information, they really should be able to evaluate it, see if there's anything valuable or that would affect this case, and maybe it would have no effect on this case whatsoever. But you really have to study that, and then you can make an educated decision, and the judge can make an educated decision once they see all the information is in concerning proctor or concerning this mental competency.
Well, on average, in your experience with criminal cases, how long does it, I don't know if you've had some major high-profile cases, but how long typically will it be until we get that opening statement from the time of the crime? Is it like usually on average a year or 2 years? Or?
Oh, geez, there's such a ballpark on that. Usually when murder is so serious and they leave no stone unturned, you have to be completely ready that it's not unusual that it's anywhere between a year and a half to, they've had it up to 5 years. It takes as long as necessary. Again, the bottom line is it's not a race to the finish line. You have to be totally prepared, and both sides have all their ducks in a row before you have the trial. You don't just say, well, we didn't have a fair trial, but we had a real quick one. You never want to be able to say that.
All right, that was Peter Elkin kind of helping us to understand a little bit what's going on there. And just like what he said here, the goal, you know, with any court trial is to have a fair one, not necessarily a quick one, although you do want it to happen as quick as reasonably possible. All right, so we're going to back up a little bit here. The next thing I want to play you is an episode from a podcast we do here at NBC 10 Boston, The Searches for Ana Walshe. And it's a podcast that I've produced for about a year and a half now, and it's all about this case and Brian and Ana and their lives, and also bringing you updates from court. So I'm going to play you an episode from a couple weeks ago, and you're going to hear audio from the last time that Brian Walshe was in court. And this was the hearing that happened on October 6th, and that was a major hearing because this is when the judge ordered him to indeed be evaluated at Bridgewater State Hospital, thus postponing the trial. So you're going to hear an exchange actually between Brian Walshe himself and Judge Diane Frenier, and you're also going to hear from a clinician on his kind of initial assessment of Brian Walshe and his mental state. So take a listen to this. I ran this through an AI for a visualizer for you guys, so just take that with a grain of salt in terms of the captions our AI generated. So there could be spelling mistakes or anything like that, but this is audio from our podcast and audio straight from the courtroom that you're going to be able to hear from October 6th when Walshe was ordered to be evaluated at Bridgewater State Hospital, thus postponing the trial. Welcome back to the Searches for Ana Walshe. I'm your host, Matt Fortin. Today, we're bringing you new details on Brian Walshe's current state of mind, amid questions about his competency to stand trial. Plus, we're learning new details about that jail stabbing we told you about that sent Walshe to the hospital, an incident his lawyers say are causing him to unravel. All of this comes from audio we've obtained of Walshe's most recent court hearing. It's when Judge Diane Frenier decided to send Walshe to Bridgewater State Hospital for 20 days to have his mental status evaluated. We're going to play you the key part of that hearing, where Judge Frenier addresses Walshe directly, followed by a doctor's testimony on his preliminary evaluation of Walshe's mental health. Take a listen.
So we're here in part because of the defense's concern, as was expressed in the two affidavits of counsel about the defendant's mental and to a lesser degree physical well-being, and specifically your concerns, counsel, with regard to your ability of Mr. Walshe to assist in his defense as he must. Mr. Walshe, I want to ask you a few questions. Do you understand that that is why we're here today?
Could you repeat the question?
Certainly, sir. Do you understand that your lawyers have expressed to me in affidavits? You can be seated if it's more comfortable. You're a tall man and it's more comfortable for you to be seated. All right?
Thank you, sir.
Do you understand that your attorneys have expressed to me in their pleadings and affidavits, we call them, that they have concern about your ability to participate in your defense of this case?
Yes.
All right. And do you understand that, so they've so informed me of their concerns, and based on what I read in those affidavits, as a preliminary step under the rules that govern these things, the rules require me to determine whether or not the court has any doubts as to whether you are competent to stand trial. Do you understand that?
That makes sense, yes.
All right. And then do you understand that if I find that there is a doubt as to whether or not you're competent and can assist in your defense, which seems to be the heart of it here, that I can order an exam, and that I did this morning?
I'm sorry, could you repeat that? You said order something?
I can order an examination of you.
Yes.
Okay. And that process is something that I thought was appropriate, and so I asked Dr. Burke, or I asked that somebody, and Dr. Burke showed, to come to assess that, what we call preliminary assessment of whether or not we should do anything further. That's what happened this morning. You understand that?
I believe I'm clear on that, yes.
All right. Do you have any questions for me? I'm going to ask the doctor some questions now, but before I do you have any questions for me, sir?
Not at this time, thank you.
All right. So, Dr. Burke, have you had an opportunity to meet with Mr. Walshe today?
I have. I believe I need to be sworn.
Yes.
Do you solemnly swear or affirm the testimony you give in the council hearing the whole truth and nothing but the truth, so help you God?
I do.
Thank you, sir.
All right, so Dr. Burke, did you have an opportunity to meet with Mr. Walsh today?
Yes, we met for about 50 minutes in the presence of his attorneys.
All right, and what can you report to me? Basically, what I'd like you to know is what materials you've reviewed and what conversations and what discussions you had with Mr. Walsh before you get to any sort of preliminary opinions.
Yes, Your Honor. In addition to meeting with the defendant today, I spoke with both of his attorneys today, both before and after the interview. I spoke with the Director of Mental Health at the Norfolk House of Correction on Friday, as well as shortly before this hearing. I also had an opportunity to review the affidavit submitted by his attorneys, as well as the affidavit submitted by his outpatient psychiatrist, Dr. Tittman, and I consulted with the area forensic director for the Department of Mental Health to determine whether he has any history of involvement with our state mental health system.
All right. And with regard to the Director of Mental Health at the Norfolk House of Correction, who is that person, just so that I have a record of it?
Her name is Ann Collins.
And is that the full amount of information that you've had access to, those interactions with those individuals that you just indicated and the documents that you've reviewed?
Yes, I did also review the 15A order, the indictments, as well as the statement of the case.
All right. Thank you. Why don't you go ahead and tell me what you think?
Yes, Your Honor. It's my understanding from meeting with the defendant and speaking with the parties that I mentioned that he does not have a history of serious mental illness, of substance use problems, of learning disability, although he did report sort of long-term problems focusing in school. He had reported to the Director of Mental Health at Norfolk House of Correction a prior diagnosis of narcissistic personality disorder that he seemed to be self-aware of. He's also reported a history of depressed mood that he's struggled with in the past, and for that reason has been involved in outpatient therapy with Dr. Tittman for many years. It's my understanding from the Director of Mental Health that he was exhibiting what she described as normative stress in the House of Correction for much of his time there. She indicated that is not uncommon and to be expected given the charges he's facing and that he had not been incarcerated previously, but that he had otherwise behaved well, not had any significant problems. It's my understanding he was stabbed on September 11th, that the attack was unprovoked, that he had not interacted with the other inmate previously, and he received medical care and was discharged the following day. It was reported to me by his attorneys that since then, he has had significant difficulty focusing. It's significantly different from their prior interactions with him where they were able to meet for 2 to 3 hours at a time, review evidence, things he might expect at trial, and that now he forgets information, he's unfocused, he seems more flustered, he seems foggier and doesn't remember things he's told them in the past. And for that reason, they've had concerns about his ability to support them in jury selection, at trial, in preparing to testify if needed. The Director of Mental Health also informed me that following the stabbing, he has appeared jumpier, more stressed. He was on the medical unit at the facility, and when he was returned to general population, asked to go back to the unit because he was overwhelmed. He has since returned to general population. She did report that prior to the stabbing, he had also been appearing more stressed as the trial was approaching, which she also believed was a normative reaction. In my interview with the defendant today, I found him to be engaged. He did appear, I would say, foggy and unfocused at times. He described having very low energy, that he feels much less focused than he does normally, even compared to how he's been in the past, that he feels jumpier. He described having interrupted sleep, having nightmares of being stabbed again in the future, and that these problems have given him cause for concern about his ability to participate in the proceedings. He clearly indicated that he very much wanted to proceed with the trial and that he's upset that he's no longer in the same condition he was before. Concerning the questions I asked him pertaining to competency, I did find that his factual understanding of the allegations was generally intact. I did not have many concerns about his ability to understand what's happening. He seemed to know the allegations, the roles of courtroom personnel, what would be expected of him in the courtroom. I did have some concerns, however, about his ability to engage in a back and forth conversation with me. He was quite focused on his lack of energy, his lack of focus. He needed questions repeated or clarified at times, and again spoke often about the deterioration. I'm not sure if he was simply having difficulty focusing, if he's having some sort of memory impairment that's getting in the way of absorbing information. He didn't necessarily describe being preoccupied with what's happened to him, but it's not clear to me whether or not that is having a substantive impact now. It's also not clear to me that this is not just related to the stress of the trial approaching. For all those reasons, I do think further evaluation is warranted at this time. I think a more comprehensive assessment would elucidate whether he is experiencing genuine trauma symptoms right now. If he is, to the extent they're impairing him. I do think that further evaluation on an inpatient basis under Section 15B would specifically be warranted. Given the magnitude of the case, the amount of data he has to review, I think an inpatient assessment would allow mental health staff to closely observe him and parse out the nature of these problems. I would also recommend the strict security of Bridgewater State Hospital, given the magnitude of the allegations against him.
All right, thank you. Does either side wish to ask Dr. Burke any additional questions? Kamal?
Yes, Your Honor. Briefly, Doctor, did you look at any police reports or any investigatory reports regarding the assault on Mr. Walsh?
No, I was not provided those documents.
And did you met with the defense counsel? You didn't have any conversations with anybody from the Commonwealth?
I did not speak with the Commonwealth about the case specifically, no.
And did you speak to Dr. Tittman or just his affidavit?
I was made aware of the affidavit shortly before I was going to testify, and at that point I provided the affidavit and did not seek to speak with him after reviewing it.
And that affidavit indicates that Dr. Tittman has not seen Mr. Walsh for 3 years?
The affidavit indicated that he had not seen him for 3 years up until shortly after the stabbing. I believe it was on September 24th or the 25th, and that during that meeting he found that his client was presenting substantially differently from how he had in the past and was exhibiting symptoms reminiscent or similar to PTSD, but that he could not offer that diagnosis at that time as he had not been exhibiting the symptoms for long enough.
And Dr. Tittman, his interview of the defendant in the affidavit, it was on Zoom?
Yes.
Nothing further at this time. Thank you, Your Honor.
Thank you. Does the defense wish to ask any questions of the doctor? That's a no. What's the Commonwealth's position at this point?
Your Honor, the Commonwealth's position at this point is that the Commonwealth would ask the court to find that the defendant is competent to proceed to trial and continue with the trial as scheduled. Certainly there may be some option to obtain some sort of further evaluation of what sounds like traumatic symptoms, but they do not rise to the level of a lack of competency. So the Commonwealth would ask that the court not send the defendant to Bridgewater at this point in time and continue this matter on the trial schedule.
Defense?
I think Dr. Burke has done exactly what he was asked to do, and he's recommended a 15B for all the reasons I won't repeat. I think it's imperative that his recommendation be followed and that Mr. Walsh be able to be further evaluated in a treatment setting so that we can get to the bottom of what is causing his inability to participate in his defense.
All right. You will hear this multiple times throughout the trial. I try to stay in my lane. My lane is not as a mental health professional. I have to rely on the mental health professionals. And based on the totality of information that's been presented to Dr. Burke, he is making the recommendation to me that a further evaluation is necessary. on the issue of whether, really, it's really not so much the issue of whether he understands. He's an intelligent man. He seems to understand, based on my own observations, what's going on in this courtroom. It's whether or not he can assist in his defense. And the court needs to have a greater satisfaction and information with regard to that. So I am going to send him for a 15B evaluation today at Bridgewater State Hospital, so that I have the benefit of whatever additional information. I expect there'll be substantial additional information based on the mental health professional's ability to examine him and see him for a more substantial period of time than Dr. Burke could in the 50 minutes that he was allowed to see the defendant.
The next step in all of this is a competency hearing. All right, I'm going to dip out of that podcast now. So that is where the case stands, basically. To our knowledge, Walsh remains at Bridgewater State Hospital under this extended evaluation period and is still undergoing that evaluation to determine his ability to competently partake in his own murder trial. So up next in all of this, there are some tentative dates on the calendar. November 17th for a final pretrial hearing, and November 18th for a tentative start date to the trial. But again, a lot needs to happen before this trial really gets off the ground, not the least of which is Walsh being cleared as competent to partake in the trial. So we're going to continue to track this for you all as we continue to get developments over the next couple of weeks to learn whether or not this trial will indeed get going on November 18th. Like I said, a lot has to happen for that indeed to happen. So we will be keeping a close eye on this and keeping you updated as we learn those updates. Until then, stay with us on NBCBoston.com. You can subscribe and follow that podcast you were just hearing an episode from. That's called The Searches for Ana Walshe, and that's available on all the streaming platforms that you listen to podcasts on. So Spotify, Apple Podcasts, you can download that and also download older episodes too to get further caught up on the case and also hear some in-depth background that you're probably not going to hear anywhere else. So that is something to check out if you are interested in following this case. Other than that, like I said, we'll keep on this and keep you posted on the latest in the Walsh case and upcoming trial. But for now, thanks so much for watching our YouTube live stream this morning. My name is Matt Fortin. I'm a digital reporter here at NBC 10 Boston, and we'll see you again soon. Thanks a lot.